Hey, the easiest way is to friends of the state of Michigan.
Will the Senate please come to order? In lieu of a devotional, we will take a moment of silence. Thank you. Are there any announcements? Seeing none, we have a House bill for introduction. H339, an act relating to removing the repeal of 7 VSA subsection 230. And it passed the House on February 27th of 2025. Please listen to the first reading.
H339, an act relating to removing the repeal of 7 VSA section 230.
Now you've heard the first reading, and it is referred to the Committee on Economic Development. Orders of the day. We now have S69, an act relating to age-appropriate design code. It passed entered the Senate chamber for notice on February 28, 2025. And it's up for second readings. Please listen to the second reading.
S69, an act relating to an age-appropriate design code.
Senator from Windham, for the report.
Thank you, Mr. President. Senate Bill 69 is an Internet child protection bill aimed at protecting the safety and privacy of children in Vermont. It requires businesses that offer certain online services directed at children to design their services in a way that is not unreasonably harmful to children. It also requires covered businesses to owe a duty of care to the children whose data is processed. The businesses this bill addresses are the larger international internet corporations, and we know of no Vermont business that would be negatively impacted by this legislation. It does not control or limit content, as kids have the same freedom of speech rights as adults in our federal Constitution. It does limit the harmful algorithms used to addict kids and increases privacy protections so that children are less likely to be targets of predators. We owe a duty of care to our children to protect them from these harms. Parents try, but parents and their children are completely outgunned by the $300 billion online marketplace. It's not just a matter of scale. The harms are baked into the programming, and parents can't change the code. Parents are devastated when they can't protect their children. This bill is only necessary because of the intentional and unconscionable harm that large internet companies are doing to our children, and they have been doing it for years. They know that they are harming children, both emotionally and physically, and they keep doing it. They are fighting to keep doing it, with attorneys and proxies doing the heavy lifting. Why are they harming our children? Because it's easier and more effective to addict a child than an adult, just as the tobacco companies did years ago. TikTok has said that they can hook an average user in 260 videos. So 260 videos sounds like a lot. It takes only 35 minutes on average to see that many videos. Years ago, kids used to work in the mines, in factories, where the damage was easy to see, and we passed laws to prevent child labor. Corporations are now secretly taking advantage of kids' developing brains to make a profit, and it is beyond the pale. We need to stop it. So what are these harms? In the last session, we heard from and about kids that they are unable to sleep, they have anxiety, they're depressed, and sometimes suicidal. An employee of TikTok explained, quote, "The reason kids watch TikTok is because the algorithm is really good. But I think we need to be cognizant of what it might mean for other opportunities. And when I say other opportunities, I literally mean sleep, and eating and moving around the room and looking somebody in the eyes, end quote. This session, we heard again how kids are targeted through coding intentionally designed to addict them to the social media site. This addiction results in a whole host of harms, such as anxiety, reduced academic performance, depression, and social isolation. Why would the companies do this if it harms their users? Again, most importantly to the companies, this addiction leads to increased screen time, and that screen time is the moneymaker for the companies. A company can charge more for ads when it can demonstrate that more people are seeing those ads, especially kids. And it turns out that American kids are particularly desirable because they spend a lot of money on the internet. We heard testimony from the Attorney General's office, the Center for Humane Technology, Chamber of Progress, Future Privacy Forum, UVM Professor of Pediatrics, the Anxious Generation, the Vermont National Education Association, a technology, privacy, and policy professor of law from Seton Hall University School of Law, the Electronic Privacy Information Center, NetChoice, Vermont Bankers Association, Public Health Nurse from Vermont, Fair Play, Tech Justice Law Project, Social Media Victims Law Center, Design It For Us, Associate Professor of Pediatrics, University of Michigan Medical School, Vermont National Education Association, General Pediatrician, American Academy of Pediatrics, UVM, Office of Legislative Counsel, Reset Tech, Young People's Alliance, Dish Network and DirecTV, Computer and Communications Industry Association, Front Porch Forum. I know sometimes we don't list all of our witnesses, but I wanted to so that you can see that we did our due diligence. So now I need to share a story that will be difficult to hear. I wish it wasn't necessary. Attorney Laura Marquez Garrett of the Social Media Victims Law Center is working with families in Vermont. She shared with our committee the story of two Vermont girls. The families allowed her to share the story with us because they hope that it will help bring change. She's filing a case this week concerning the girls in Snapchat. She used the names Shannon and Elizabeth to protect their privacy. A few years ago, 2020, the two friends joined Snapchat with their parents' permissions. I'm sorry, they joined a couple years earlier. The incident happened in 2020. So a few years ago, the two friends joined Snapchat with their parents' permissions. They entered their real ages and chose non-public profiles. So they did everything right, everything you're supposed to do. The girls soon showed the classic signs of compulsive use: trouble sleeping, no interest in previous activities such as gymnastics, just a need to keep using Snapchat, mostly on gaming consoles. But it gets worse. Snapchat has a friend recommendation feature and suggests other users as, quote, friends you may know. They provided Shannon's profile data to a 24-year-old man who lived nearby, recommending that they become friends. The girls snuck out of their house and met the man at a middle school. He drove them to an empty field, plied them with vapes and alcohol, and raped Shannon. She was 12. He drove away with their shoes and coats. It was winter, and they could have died. Fortunately, an off-duty police officer saw them and took them home. 5 years later, they are ready to tell their story. Because Vermont seals sex abuse cases when they are filed, this data won't be public soon, but the attorney told us that she has a case in Connecticut that is exactly the same profile. So now I'll go through the language of the bill as amended and how it addresses the harms. The amendment is in your calendar, page 114, and you should have received the bill as introduced. Section 449A is the definition section. It takes up a significant portion of the bill, and included in this section is the definition of covered businesses, which is something we talked about a lot, which among other things is limited to businesses that generate a majority of their annual revenue from online services. Sensitive data is also defined, which includes data that a reasonable consumer would not want shared or sold to a third party. This includes things like your social security number, health data, and obviously for the girls, it was their profile data. Section 2449B lists what is excluded from this bill. Governments are excluded, as are entities that employ journalists as a majority of their workforce. One of the amendments that we did provides that an otherwise covered business that processed the data of less than 25,000 consumers in the previous calendar year is excluded. Also excluded, and this is also part of the amendment, are covered businesses that process the data of less than 50,000 consumers and gross less than 1 million in annual revenue in the previous calendar year. Again, we do not know of any Vermont business that would not be exempt. Sorry for the double negative. So we believe, especially with the amendment, but even before the amendment was made, that there were no Vermont businesses that would be impacted by this. We asked businesses to testify on the bill. The Banking Association, as I said, took us up on it, and we did add an exemption for them. Section 449C sets the minimum duty of care to minors required of covered businesses. Covered businesses are required to design their online services in a way that does not cause emotional stress or compulsive use. Section 2449D requires covered businesses to have their default privacy settings set to the highest level of privacy, including preventing a child's social media account being publicly visible. It also requires the default privacy settings to prevent an unknown it also requires the default privacy settings to prevent an unknown adult from contacting a child on their platform and from sending a push notification to a child. These regulations would prevent the pedophile as friend recommendation by Snapchat in two ways. The girls' accounts would not have been public, and the unknown adult would not have been able to contact Shannon. Section 2449E requires covered businesses to provide their privacy information and detailed descriptions of their algorithmic recommendation system. This would help parents and kids understand how their children's information could be used and how the algorithms work. It might encourage companies to stop using these algorithms or to modify them if the public response was negative. Section 2449F prohibits covered businesses from collecting or sharing the personal data of a child for any reason besides providing the service requested by the child or using the personal data of a child to recommend media to the child unless specifically requested. So what that means is unless the child specifically asks for something, because again, kids are entitled to get the information that they want. They can do searches as much as they want. But this refers to the internet provider sending information that is not wanted to children. It would also, this same section would also prohibit companies from pushing notifications to kids between midnight and 6 a.m. This is really a problem for kids. It's been found that if Facebook just changed its speed a little bit, kids could actually sleep at night. So this would prohibit notifications between midnight and 6 a.m. The Attorney General is given authority to adopt rules prohibiting certain design practices that would lead to compulsive use, and to update these rules at least every 2 years to keep pace with emerging technology, because this is changing constantly. Again, a company following these regulations would not share the personal data of children. Limiting the timing of push notifications, as I said, would allow children to get a good night's sleep. The Attorney General rulemaking would keep the regulations up to date and allow a process that could include businesses so they could provide recommendations, as opposed to having the legislature having to come and modify this. Section 2449G sets forth the parameters for how a covered business can determine the age of its users. A covered business is required to delete the personal data it collects for determining the age of the user. The Attorney General is given the authority to adopt rules that help covered businesses develop appropriate age assurance methods. The girls in the story would not have been identified as 12-year-olds to the perpetrator if this regulation was followed. Evidence supports the intentionality to connect young girls to adults who may be predators. 17 and 18-year-old women on Snapchat say that they no longer receive the friend recommendations that they did when they were younger. Evidently, they have aged out of the preferred demographic. Section 2449H sets forth the enforcement mechanism of the bill. This bill calls the Vermont Consumer Protection Act into play, allowing the Attorney General to adopt rules and conduct civil investigations for violations. And this is the same enforcement that we had in last year's bill, which passed unanimously out of the Senate. Finally, the last two sections help clarify that the bill does not conflict with federal law or restrict the freedoms children have when it comes to accessing content. One more story about a specific harm to a different but particular group of kids. Quoting again from testimony of Laura Marquez Garrett, quote, "Many of you have seen reports of teens sextorted and dying by suicide. Please look closely and you will notice that many of these teens are high school athletes. This is not a coincidence. It is the result of the fact that Instagram, one of the most commonly used platforms by schools to tout sports teams, is designed and being operated in a way that makes it easy for predators to find and target those children specifically." I have to believe that if adults knew that this was happening, they would do something. We are those adults, and it's time we show that we have a duty of care to our children. They deserve no less. So I ask for the support of the members of the Senate, and thank you for your time.
So the question is, shall the bill be amended as recommended by the Committee on Institutions? Senator from Rutland.
Thank you, Mr. President. I found that report very, very good, but I'd like to interrogate the reporter if I could.
The reporter is interrogated.
So twice the reporter made mention of the fact that there was a certainty, and if I'm mischaracterizing it, I'm sure you'll let me know, that there's a certainty that no Vermont businesses would be affected by this, or then you said it in a different manner, that they would be exempt. And I'm wondering, because that was one of my concerns with the bill, whether you could share the data by which you came to that conclusion, or on the basis of what was employed to make that statement. I think it's important.
Okay. Thank you, Mr. President. Good question. We heard from Ledge Counsel particularly and the Attorney General that the entities providing these services are the large internet companies, and none of those companies are based in Vermont.
Okay. I thank the reporter. Could I ask for a brief recess, Mr. President, and ask the other members of the Republican Party to join me over in the corner?
Hearing no objections, we'll take a brief recess.
Things change.
So you know, right?
It did.
Will Senate please come to order?
Said you were all very.
Senator from Rutland.
Thank you, Mr. President. I thank the reporter. I'm all set.
So the question is, shall the bill be amended as recommended by the Committee on Institutions? Senator from Rutland.
Thank you, Mr. President. Again, I appreciate, if I could request to interrogate the brief of the bill.
The reporter is interrogated.
Thanks, sir. I just have a few questions. I was an original co-sponsor of the bill, so I feel I have a bit invested. I do have some questions because bills morph over time before they land back on the floor. First question is, you had a very comprehensive list of witnesses, and I appreciate that. I was just wondering if the U.S. Chamber of Commerce or the Vermont Chamber of Commerce had the opportunity, or some organization very similar to them, had the opportunity to weigh in.
The chamber had the opportunity, but they did not weigh in.
Okay, thank you. Are there other states now that have this, a similar legislation enacted?
Yes, and so that I can give you the best answer, well, yes. May I have just a 1 minute conference?
We'll take a brief recess. We all set? Will Senate please come to order? You may continue.
Thank you, Mr. President. Yes, the state of California has a similar, similar legislation.
Thank you, Mr. President. Is the legislation enacted or is
No.
it pending? Just for clarification.
Sorry for the interruption. It is pending. The lawsuit that has stopped its inaction had to do with freedom of speech by the company rather than the child. And so it wouldn't, that situation does not live in this bill.
I thank the reporter and thank Mr. President. Last question, what is the enforcement mechanism for the bill? Which agency within Vermont state government would actually enforce the legislation?
Thank you for the question. The Attorney General would enforce the legislation.
Thank you, Mr. President. Thank the reporter.
Are you ready for the question? Senator from Essex.
Thank you, Mr. President. I wasn't going to stand to speak against this bill, but sometimes you just got to do what you got to do. Mr. President, if you want a kids code bill, then let's have Vermonters sit in a room and we'll write a kid codes bill. This bill was written by California that can't even enact the law. It's in litigation already. We could sit in a room in 2 hours and bring all the stakeholders in, and we could. And I believe that there should be a kids code bill, and I want to be a kids code bill. This is a bill written by trial lawyers to catch middle to small companies and trip them up and put them in litigation, therefore causing their insurance companies to say, hey, just settle that thing, just settle it out. It is an attorney's dream bill. I have fought with that. I was honest with my chair all the way through it. And this is to police internet companies or social media companies. Nowhere in this bill is the word social media even said. It isn't nowhere in there, is it said at all? It was not written by Vermonters. We should get back, if we want to protect Vermont businesses and we want to protect Vermont kids, then we should be writing our own bills. We should get in there, we should get in the room, bring the stakeholders in, sit right there, do what we need to do, and write a great bill. This is not the avenue to do that. This is written from a state, 17 states over, and it's just not, it doesn't have the Vermont values I believe that it should have. This bill is going to get challenged immediately, just like California's bill in the courts, and I have some good indication that maybe if it continues the way that it is, that it'll probably be vetoed. Let's just sit in a room, write a kids code bill, and do with what Vermonters do, protect our kids, protect our businesses. This isn't the bill to do that. Thank you, Mr. President.
Senator from Chittenden.
Thank you, Mr. President. This bill is about the buying and selling of our children's data and personal information. And I want us to be really clear that I don't think we have a different value around that than California or Maryland or New York or Texas or any of the other states that have looked at this, or frankly, the bipartisan group in Washington that has been looking to advance the Kids Online Protection Act that has been stymied. We have taken this issue up over 2 biennia. And as we have done that, we have had a very strong level of bipartisan, tripartisan, nonpartisan support for this issue because it involves the safety and mental health of our kids. I will say that big tech and social media companies will say this is a hardship. This will put smaller advertisers out of business. This is too difficult to implement. This is absolutely the law of the land in the European Union and the UK. They have been meeting these standards across the globe for, I would say, at least 7 years now, almost a decade. They are studying right now the hopefully positive impacts that's had on kids, but they have not seen some kind of huge disruption in the economy because we can't put our children's information up to the highest bidder. Last biennium, when we took this up, I put a chart on people's desks, and it showed something that I hope folks would find interesting, because I am a digital native or a geriatric millennial or whatever you want to call it. I started with social media like Facebook in 2008. And in 2008, it was very experimental, it's very embarrassing, but it just did not have the same harms. The charts that I shared on the floor last year showed that suicide, depression, all of these mental health indicators changed in 2011. Now, if you, like me, were on social media at that time, they started to get incredibly sophisticated about their advertising to kids. That is when they figured out how to get people hooked and then monetize their attention. And that is when we saw a spike in mental health issues for kids. That is when we saw that kids were having trouble sleeping and suicide rates were going up. I just want to say that again. It's when advertising changed. It's when we could fully monetize our kids' attention. So why are kids in the US, why are kids and not kids in other countries who have laws protecting them while allowing them access to the same social media platforms, to the same opportunities to connect with peers of their own age and not experience predation? I also want to say the business community was involved in writing the bill that we presented last biennium. The Center for Humane Technology, which is a national organization, one of its leaders used to actually be the head of VEPSI in Vermont. And he felt really comfortable going back to our business community and asking them to make sure that this worked for Vermont businesses. And the committee this year would be hard pressed, I'm sure, to find a business who wanted to come forward and say, no, a majority of what we do is buy and sell children's information. And we'd like to please keep doing that. That is very different than conversations we can have about other bills. But there is a reason, Mr. President, that this was unanimous from those present and voting last biennium. And I would really hate to see a lot of that bipartisan support lost now because of false flags and straw men in terms of who might be heard in the business community where the real harms that we're talking about are harms to teenage girls, are harms to kids who are figuring themselves out as they get older, are harms to kids whose lives are cut short by the predation they experience online. And if you are willing to vote against this to protect the interests of maybe, unlikely, a couple of businesses in Vermont over the well-being of our kids. And I'll remind folks, last biennium, we heard from some whistleblowers at Meta who said that they had been part of meetings where the question was, hey, Vermont has a lot of Instagram users, but the kids aren't staying online long enough. How do we keep their attention longer on this app, hours and hours a day? And we're gonna protect maybe a couple of businesses over a majority of our kids who use social media and are losing sleep and losing their lives? I have a problem with that. I have a problem with that. I'll just end by saying, Mr. President, I was really heartened to see Jonathan Haidt get involved in this conversation. For those of you who don't know, Jonathan Haidt has written probably 2 of the premier books on this topic and pulled a lot of the literature and research together, The Anxious Generation, but also one that colleagues on all sides of the aisle might appreciate, which is called The Coddling of the American Mind. And in The Coddling of the American Mind, Jonathan Haidt's central argument is that we overprotect adult mental health, and as an adult, I'd say we underprotect our physical health. But when it comes to our kids, we way overprotect their physical well-being, and we leave them to the wolves when it comes to their mental health. That chicken is coming home to roost right now in our schools, in every facet of society that you see. That we want to put bubble wrap around our kids, but they could be experience predation by a 24-year-old online, and we can't do anything about that. So I would ask folks to really focus on this bill as harm to children. We can have a very different conversation about adult consumer data, and people know I have my feelings on that as well. But standing alone, the Kids Code is about harm to our children in a climate we know is hurting them in the digital world. And so, Mr. President, I ask that when the vote is taken, it be taken by roll.
Senator from Chittenden has asked that when the vote be taken, it be taken by roll. Senator from Washington.
Thank you, Mr. President. I hesitate to stand up and be a footnote to the senator from Chittenden's very impassioned presentation. But I was on the committee last year when we did the original version of this bill. But I've been on the Finance Committee for a long time, and we do a lot of work in the cost of education. One of the leading drivers in the cost of education right now is providing mental health counselors to students in our schools. And that rise in mental health issues came about at the same time that social media became actively involved in the lives of our children. My children were in the public schools in the 90s. I've asked them. There wasn't the widespread mental health issues that there are now. To the point, I believe it's Seattle, but one city is suing for help with their education costs. And I remember saying in committee, if they succeed, I think I might just put a bill in to have Vermont do the same thing, because there really does seem to be a connection, and it is impacting our property tax bills.
Are you ready for the question? The question is, shall the bill be amended as recommended by the Committee on Institutions? Are you ready for the question? If so, all those in favor? Whoop. Oh, roll call. The secretary may commence to call the roll.
Senator Baruch.
Yes.
Senator Beck,
No with explanation.
Senator Bonner,
Yes.
Senator Brennan,
Yes.
Senator Brock,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Cummings,
Yes.
Senator Douglas,
No with explanation.
Senator Bueller,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hart,
No with an explanation.
Senator Hashi,
Yes.
Senator Heffernan,
Yes.
Senator Ingalls,
No.
Senator Lyons,
Yes.
Senator Major,
Yes.
Senator Mathers,
Yes.
Senator Norris,
No.
Senator Kirschling,
Yes.
Senator Plunkett,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Bohofsky,
Yes.
Senator Watson,
Yes.
Senator Weeks,
Yes.
Senator Westman,
Yes.
Senator White,
Yes.
Senator Williams,
Yes.
Those voting yes, 25. Those voting nay, 5. And we have, what did we do? We have we have amended the bill as recommended by the Committee on Institutions. Oh, we've got some explanations, yes. Which one? Senator from Caledonia for explanation.
Thank you, Mr. President. S69 has a lot of potential to address a real problem. I look forward to a more fully developed bill before we adjourn.
Let's see, Senator from Orleans.
Thank you, Mr. President. The harms in this bill is trying to address are very, very, very real, and I'm a large advocate for those problems. But I just do not believe that this bill will accurately identify the minors that it's trying to protect. On page 21 that we all have, the Attorney General has a lot of leeway in the rulemaking for that, and I don't believe that the age verification methods that are going to be implemented as we are taken in committee with our testimony are going to be accurately implemented. So that is why I voted no, and I agree with the Senator from Caledonia that a more fleshed out bill is needed, and that it is possible to protect minors. I just don't believe this bill will do it. Thank you, Mr. President.
Senator from Orange.
I voted no for the bill because, again, I thought that we could amend it to do better for the minors. And, you know, it's, being a rookie, it's kind of tough for me to get up and say this, but that's the way it is. I just felt like that bill can be, we could put more emphasis on that than what was there. And if this bill came from the California, I feel like we should do it here in the House, in our Senate chambers. We should have our own Senate bill for that instead of mirroring off somebody else. So that's just my gut feeling. Thank you for listening to me, President.
The question is, shall the bill be read a third time? Are you ready for the question? Senator from Franklin.
Thank you, Mr. President. May I interrogate the reporter of the bill?
The reporter is interrogated.
In looking at the bill, Mr. President, as amended, I do not see anything that relates to a private right of action. Is it correct that there is no private right of action associated with the bill or with any other consumer protection laws that may be implicated by the bill?
It does include the existing consumer protection laws, and there is a private right of action.
And
But that's
does
not,
this incorporate that, Mr. President, when the applicability of this provision applies?
it does not delete the existing private right of action that's in our statutes.
Does the private right of action that's in the statute right now apply when these particular provisions apply?
Yes, I would say, yes.
Okay, so
As it does in any other consumer protection,
so there is a private right of action here. Thank you, Mr. President.
just the existing one, and that was also in the Kids Code bill last
Yep.
year.
Thank you, Mr. President.
Are you ready for the question? The question is, shall the bill be read a third time? If so, all those in favor, please say aye. Aye. All those opposed, nay. The ayes appear to have it, the ayes do have it, and you have ordered third reading. We now have on the calendar for action S60, S50, no glasses. An act relating to increasing the size of solar net metering projects that qualify for expedited registration. The bill was referred to the committee. What am I missing now? On Natural Resources and Energy, and please listen to the second reading.
S50, an act relating to increasing the size of solar net metering projects that qualify for expedited registration.
I recognize the senator from Rutland.
Thank you, Mr. President. Here to report Bill S50, which proposes to increase the size of solar net metering projects that qualify for an expedited approval process from 15 kilowatts to 25 kilowatts. Because the technologies for solar panels have improved, a smaller solar panel will generate the same electricity as the original larger panels. You can now place a 25-watt self-generation and net metering project, think of your backyard project, on a footprint that would previously accommodate a 15 kilowatt. Section 1, 30 VSA Section 810 states that in accordance with the section, the Commission shall adopt and implement rules that govern the installation and operation of net metering systems. The rules shall establish standards and procedures governing applications for and insurance on revocation of a certificate of public good for net metering systems under subsection 248F. Pre-application submission of this title. Think of Act 248 as Act 250 governing power generation. Subsection F, which applies to the application for a net metering system, changes the capacity of that system from 15 to 25 kilowatts. Subsection G is changed to read, the rules shall establish an expedited registration for procedures for net metering systems up to 25 kilowatts in size. Section 2, rulemaking. Public Utility Commission shall update its rule 5.100 to allow ground-mounted photovoltaic net metering systems of not more than 25 kilowatts to qualify for expedited registration, and it is the intent of the General Assembly that the Commission shall allow systems of up to 25 kilowatts to use the expedited registration before the rules are updated. Section 3, the effective date. This act shall take effect on 1 July 2025. Your Senate Natural Resources and Energy Committee received testimony from our very own Chair Ann Watson, Legislative Counsel Ellen Skolsky, and Peter Sterling of the, better get this right, the Renewable Energy Vermont. The bill passed out of committee 5-0-0, and we recommend passage. Thank you, Mr. President.
The question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S50. Now have S28 on the calendar for action. An act related to access to certain legally protected health care services. Referred to the Committee on Health and Welfare. And please listen to the second reading of the bill.
S28, an act relating to access to certain legally protected healthcare services.
Senator from Chittenden.
Thank you, Mr. President. In past sessions, we've passed patient and provider protection laws for cell therapy, as well as for, more recently, our Vermont's SHIELD laws. The SHIELD laws provide support for patient access to reproductive and gender-affirming care services. The laws provide protection from legal tactics that we see in other states used to harass those seeking and providing such services. S28 fills some gaps and improves our current policies. S28 is also an important step for consumer protection for both patients and providers. Among other provisions in the bill, protection is offered for patients from misleading information and advertising by healthcare services, and better defines what constitutes unprofessional conduct by healthcare providers. As we go in and begin looking at the bill, we'll see that there's reference to professionals who are licensed both by the Office of Professional Regulation and the Secretary of State's office, and also those folks like doctors of osteopathy or advanced practice nurses are licensed through the Office of Professional Regulation. And the bill also refers to folks who are licensed and overseen, regulated by the Board of Medical Practice. And this includes professions such as medical doctors and physician assistants. So as you begin looking at the bill, we will be talking about those professions that are regulated by those two different organizations. Turning to Section 1 of the bill, begins with some exemption, another exemption for public inspection of records. So I'd remind us that there are currently public exemptions for a number of things relating to healthcare, including prescription data identification or patient safety surveillance data or information about a prescriber who's prescribing a specific drug. So this adds a number 44 and includes protection for an exemption from public records and inspection for folks in both OPR, Board and Office of Professional Regulation, and Board of Medical Practice, or other related licensing entity. So if the records contain telephone numbers, email addresses, or physical or mailing addresses of an applicant or a licensee, the value of this is to protect the person who's applying from having intrusion into their personal lives. They would be putting in place information about their public address or their office. Section 2 of the bill relates to unprofessional conduct for Office of OPR, regulated professions. And we're going to see some redundancy through the bill as we talk about Office of Professional Regulation and Board of Medical Practice. So we'll be coming back to some of these sections will seem very similar. So Section 2 sets forth what constitutes unprofessional conduct for OPR regulated professions, including advertising that is intended or has a tendency to mislead, as well as to deceive, to include permitting one's name and address to be used when not actively overseeing the services. Section 3 of the bill, healthcare services under Consumer Protection Act. This expands the scope of the chapter from what are called pregnancy services centers to expand the coverage to healthcare services. When we passed the bill last year, it was very much directed toward one type of healthcare service, or to look at unprofessional practice and to look at advertising. And your Senate Health and Welfare Committee felt very strongly at the end of the year that it should not be directed toward one type of entity, but rather toward all healthcare services, to ensure that information is given accurately and appropriately. So this section 3 deals with the scope of what constitutes a violation of the Consumer Protection Act from advertising by healthcare services and that are performed in the state of Vermont. And then we also see a repeal of language that underlies the changes that are in the bill. Section 4 through 6 relate to fetal death reporting, mostly technical changes. So to add in naturopathic physicians into those who are reporting, and then for statistical purposes requires reporting of fetal deaths and changes the time frame to 2 years for keeping the information rather than 5 years, and that's consistent with federal law. Section 7, so those were sections 4 through 6. I think I said 4, but it's 4 through 6. Section 7 relates to unprofessional conduct for Board of Medical Practice regulated professions. So now these are the folks who are MDs, PAs, and others. And this allows for a regulation of what constitutes unprofessional conduct for the Board of Medical Practice regulated professions, and to include advertising that is, if it includes advertising that's intended to deceive or mislead, that would be unacceptable. The section also includes and allows for the use of a questionnaire during telemedicine for the prescription of a medication to a patient to terminate pregnancy based on an adaptive, so an adaptive questionnaire would be used and there would be information shared with the physician or the practitioner and then an ability to communicate with the patient. This comes from guidance for the Federation of State Medical Boards and is used by most states across the country. It is also consistent with Vermont law that no public entity shall prohibit a provider acting in the scope of practice from terminating or assisting in the termination of a patient's pregnancy. Section 8 deals with advanced practice registered nurses and utilizing an adaptive questionnaire, and this is similar to what we just looked at under the Board of Medical Practice. Advanced practice nurses are under OPR. Section 9 provides for conforming revisions to statutes for the Board of Medical Practice regulating professions. So it makes conforming revisions to unprofessional conduct statutes for anesthesiology assistants, physician assistants, and radiology assistants. So as we go through sections 9, 10, and 12, that's replicated language from the prior professions under the Board of Medical Practice. Section 11 provides for the confidentiality of prescriber information on medications for legally protected health care. Upon request, it allows for pharmacists not to list a prescriber's name on a fulfilled prescription for medication for gender-affirming care services or reproductive health care services, but instead to list the name of the facility where the prescriber works, and this again is protective for folks who may be harassed if someone should identify that information. So, Mr. President, overall, the bill is an improvement over underlying statute. It allows for an improvement to what we consider to be or identify as unprofessional conduct, but it also then provides for patient protection from such things as misleading advertising. We heard from the sponsor of the bill, a lead sponsor, Senator Ruth Hardy. We heard from the Vermont Medical Society. We heard from Planned Parenthood. We heard from Ledge Council. We heard from Allison Despathy, a parent from Danville. We heard from Mike Fisher, our healthcare advocate. We heard from the Vermont Association of Hospitals. We heard from the executive director of the Vermont Board of Medical Practice. We heard from a family physician. We heard from the Vermont Med Society. we heard from the Office of Professional Regulation, and we also heard from a pharmaceutical association in the state of Vermont. The vote was 4-1-0. Thank you, Mr. President.
The question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Senator from Rutland.
Thank you, Mr. President. May I interrogate the reporter of the bill?
The member from Senator from Chittenden is interrogated.
Can you explain to me the purpose of the change proposed in section 5222 subsection D?
Do you have a page number for that, Mr. President? Oh, yes, the fetal death reports. Yeah, thank you. They're for statistical purposes only. Obviously, it's an improvement to what could happen to someone if they have a spontaneous miscarriage or a loss of a fetus, and there are folks who will use that to the detriment of the individual.
Thank you, Mr. President. So further, did you have anybody from law enforcement testify regarding what that might mean for any kind of a criminal investigation?
No, Mr. President, this is not related to a criminal investigation. It's related to statistical data to understand maternal and fetal health, child health.
So, Mr. President, what would, in the case of malpractice, how would that have anything to do with it? Malpractice.
Could you explain what you mean by?
Well, if the fetus is destroyed and it's not available in the records, what if somebody brought a malpractice suit?
That would be outside the scope of this bill, Mr. President.
Okay. Thank you, Mr. President.
The question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Senator from Orleans.
Thank you, Mr. President. So I was the sole vote against this bill in committee for section 2493 of the Unfair and Deceptive Act. I believe that this portion of the bill is unconstitutional under the First Amendment. The attorneys that I sent it to flagged that immediately as unconstitutional. I do not believe that shifting the regulation of speech changes its constitutionality. I brought up those concerns in committee. They weren't addressed. I have also concerns over the controlled speech over the internet and social media. There's a lot of constitutional issues there, especially if the case is coming up in the Supreme Court recently. So I just wanted to flag that for the body. Thank you, Mr. President.
Are you ready for the question? The question is, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it. And we have amended the bill as recommended by the Committee on Health and Welfare. Now the question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading. That completes the orders today. Senator from Chittenden.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until 1 p.m. Thursday, March 13th. And if I might lead off announcements. Senators no doubt know that the confirmation vote for Secretary Saunders happened yesterday in the Education Committee. It was a positive vote, and it has moved to our notice calendar and from there to the floor tomorrow. So I just want everybody to have a heads up that we will have that confirmation vote tomorrow first thing. That is at first announcements. So please be here promptly, and we will take up that vote at that time. Thank you, Mr. President.
Are there any announcements? The Senator from Chittenden, could you withdraw your motion pending a move to bring a bill onto the calendar? To move a bill, sorry.
I withdraw my adjournment motion pending the removal of the bill.
Senator from Wyndham.
Thank you, Mr. President. Pending entry on the calendar, I move the rules be suspended in S29, an act relating to establishing the chloride contamination reduction program at the Agency of Natural Resources be referred to the Committee on Judiciary, with the report of the Committee on Natural Resources and Energy intact.
The senator from Wyndham has moved that the rules be suspended and S29, an act related to establishing the chloride contamination reduction program at the Agency of Natural Resources, be referred to the Committee on Judiciary with the report of the Committee on Natural Resources and Energy intact. Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and we have moved S29 to the Committee on Judiciary. Senator from Chittenden.
With that said, Mr. President, pending further announcements, I would move that we stand in adjournment until 1 p.m. Thursday, March 13th.
Are there any announcements? Senator from Washington? Oh. Senator from Windsor? I was looking that way, and three of them, I think, were trying to stand up at once, so.
Thank you, Mr. President. Tomorrow, the Climate Solutions Caucus will not be meeting. We are alternating our schedule with the Women's Caucus. So if you would like to attend the Women's Caucus, they will be meeting at noon. Instead, you are also invited to join the Youth Lobby, which is the climate advocacy wing of a youth activism organization. They will be in the building, so you'll be hearing a lot about climate change, and you're welcome to join. And in the pavilion, if you're not going to the Women's Caucus, the lunch that they are hosting. So again, I'm announcing free food related to climate change tomorrow in the pavilion, which you are invited to join. Thank you.
Are there any announcements? Senator from Washington.
The Senate Appropriations Committee members will get a bit of a break due to scheduling. We will not meet till 3.
Senator from Washington.
Thank you, Mr. President. Senate Finance will meet 5 minutes after the fall of the gap.
Senator from Rutland.
Thank you, Mr. President. Much like the Senate Finance Committee, Senate Government Operations will meet 5 minutes, please, after the fall of the gavel.
It's a bit like musical chairs in reverse. Senator from Wyndham.
Thank you, Mr. President. Senate institutions will be have a little bit more of a break and meet at 1:20, but please do be on time because we have witnesses.
Senator from Windsor.
So reward yourselves after a day of hard work and come and join me at Farmers Night tonight, 7:30 in the House Chamber. We are having the wonderful Lisa Jablow and the Vermont Symphonic Winds performing there. There is going to be some lovely music that's played. There are going to be vocalists and musicians. And I think vocalists are musicians, but anyway, it's described as a vibrant performance of classical and contemporary selections. So I urge you to come, take a load off your feet, take a break from this hard work, and join me for an hour.
Senator from Wyndham.
2:20, we don't need to go back in time.
But only if we could. Are there any more announcements? Seeing none, the senator from Chittenden has moved that we stand in adjournment until 1 p.m. Thursday, March 13th. Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and we will stand in adjournment until 1 p.m. Thursday, March 13th.